Yeah, yeah, I mean,
The application of Mr. Albert Roberts, 4345 Clinton Road, New Hartford, New York. Mr. Roberts is seeking a use variance for a veterinary clinic at 4345 Clinton Road. Zoning in this area is RB4 neighborhood business, and a veterinary clinic is not a permitted use in this zone, therefore necessitating the use variance request. This application was tabled at the October meeting.
welcome back.
How you doing? I didn't bring anything new, because I really don't have anything new to add, other than what we handed in, which was some paperwork stating that we have had realtors show the property. We've had it on the market. We haven't had any real action on it. I think the use is about as low impact as you can get. I mean, I thought it was pretty much a slam dunk when I came here. We've handed in what I felt was we were lacking. I really don't have anything more to add, other than, you know, like I stated before, it's a veterinarian clinic for cats only. You know, no boarding, no incinerator, or whatever you want to call it. Pretty cut and dry. I mean, it's pretty simple usage. Probably no more traffic than a homeowner living there with 3 or 4 cats. About all it is, so.
Okay.
I mean, you've got the paperwork that I was lacking, I turned in. That's about it.
Questions for the, anybody have any questions for the applicant? Fred?
No.
John?
Yeah. Is that property gonna get cleaned up? The last time I was there, I only was out in front, and I looked between the buildings, I didn't go out back and look.
Well, the material that's there is there to build a berm around the property, to put a buffer between myself and Tom said. I've already talked to Tom, he's fine with everything, of course it's on my property, but yeah, I mean, we're waiting to get approval so we can go in there. I've got a machine loaded, ready to go tomorrow to start, you know, constructing the site and putting the parking lot in and so on and so forth. I have this week and next week to pave, and then it's done. So
all them old
Prop-
bricks and then a big
yeah,
pile of stone and stuff.
most of it's being used. It's there for a purpose.
Yeah, I'll also know.
Okay. Lenore, anything for the applicant?
No, not at this.
Byron? Tim?
You said last time you were paving the front section, correct?
Correct.
And then you were doing some shrub work or some stuff in the front. And how many parking spots were you putting? I just don't remember.
I think there was like 6 or 7.
7, okay.
And then there's, you know, there'll be parking in the rear for, he has an extra employee or, you know. But I don't even imagine he's gonna need parking in the
Right,
rear.
and then you're gonna put a sign in the front. I'm sure the doctor wants a sign in the front.
Right, and we'll go for a sign application, whatever that process is.
Okay. And you're gonna be able to get the parking lot, all that in before the tenant gets in there?
Oh, yeah, I mean, like I said, this week and next Wednesday, the plant's closed.
Okay.
Most of them, Barrett's may stay open a little bit later.
Yeah.
If they start a project that they've got, you know, there's that activity going on in the arterial,
Yeah.
so the plants are staying open a little later, but,
Yep.
you know, I wanna get it done before the weather
Mhm.
gets completely sour.
Okay.
I have a question. I'd like,
Wait a minute, they're not.
I'm
Yeah,
sorry.
We'll be
I'm
with you
sorry.
shortly. Okay, well, at this point now, we'll open it up to the audience. Is there somebody in the audience who wishes to speak on behalf of this specific application?
For or against?
No, just,
Anyone?
yeah. You had comments first, right?
Yeah, I have comments, right. Is that what you want, Randy?
Yep.
Okay. Good evening, ladies and gentlemen. My name is Ed Whiter. I'm co-founder of Concerned Citizens. I've had the opportunity to review Mr. Roberts' application, and what I did find is that the application as prepared did not comply with the requirements of the law. There were several distortions as articulated as to the type of use he wanted. There's references made to a veterinary clinic, there's a reference made to a hospital. We're not really sure what was the intent behind it. I did hear there was some clarification this evening, but the most important thing, as the board is aware of, there's 4 individual factors that are required to be taken into consideration. And it's my understanding in reviewing the videotape as taken by Mrs. Lawrence at the last meeting, Mrs. Stanislaus raised the issue concerning financials. What I'd like to do is and once again, my presence here is neither for nor against. However, I am here on behalf of the town residents to ensure that the interpretation is done in a manner consistent with the law. And I'd like to start as follows. And I did present a copy to Dory for the record, and I will articulate our position here and go through each one of the 4 points, which you as the board will do yourself. For the members of the public here, I'd like to give them some background itself. A use variance is the authorization by a zoning board of appeals for the use of land for a purpose which is otherwise not allowed or is prohibited by applicable zoning regulations. The Department of State writes in their handbook titled Zoning Board of Appeals, dated 2011, this power of the Board of Appeals must be exercised very carefully lest there be a serious conflict with the overall zoning scheme for the community. The showing required for entitlement to a use variance is therefore intended to be a difficult one. No such use variance shall be granted by a Board of Appeals without a showing by the applicant that applicable zoning regulations and restrictions have caused unnecessary hardship. In order for unnecessary hardship to be proven, the applicant must prove 1. The applicant cannot realize a reasonable return provided that the lack of return is substantial as demonstrated by a competent financial evidence. I will go back to number 1 in detail, but I will cover point number 2, that the alleged hardship relating to the property in question is unique and does not apply to a substantial portion of the district of neighborhood. In the case of Hickox versus Griffins, the court stated there must be at least proof that a particular property suffers a singular disadvantage through the operation of a zoning regulation before a variance thereof can be allowed on the ground of unnecessary hardship. The court has held that it is not the uniqueness of the plight of the owner, but uniqueness of the land causing the plight, which is the criterion. The land where the property is located has the same advantages and disadvantages as the rest of the parcels in that area. Point number 3, as put forth by the state of New York, that the requested use variance, if granted, will not alter the essential character of the neighborhood. According to the Department of State, one court has held that the applicant will fail this 3rd test if it is shown that the proposed project would stimulate a process which in time would completely divert the neighborhood's complexion. In other words, the proposed project need not in and of itself alter the character of the neighborhood if it is shown that the project would set a pattern for future development that would in time alter the neighborhood's character. And lastly, point number 4, that the alleged hardship has not been self-created. According to the Department of State, they cite Carriage Works Enterprises Limited versus Siegel. In addressing self-created hardship, the court stated, the courts should not be placed in the position of having to guarantee the investments of careless land buyers. The same advice should apply to Zoning Board of Appeals. It is well settled that a use variance cannot be granted where the unnecessary hardship complained of has been created by the applicant, or where he or she acquired the property knowing the existence of the condition she or he now complains of. The Department of State concludes their explanation of use variances by saying, the rules laid down in the statutes and the applicable cases are requirements. They must be used by zoning boards of appeals in reviewing applications for use variances. Furthermore, and this is the most important part, the board must find that each of the elements of the test has been met by the applicant. Reviewing the request before this board, it is clear that the applicant is unable to meet the burden of proof on all 4 counts, but I would like to expound with regard to number 1, the financials. That it's my understanding that the applicant submitted a delinquent tax bill. In accordance with the state of New York as set forth in several appellate court decisions, that does not meet the test of time. That can't even be considered. The test for financials rests with the individual obtaining a third party who is independent of that individual and restating for the board's purpose an analysis as to whether or not there could be a profit. But we also have a two-pronged scenario here. The applicant on his property, you have 43, which is a house, which could be rented, which was not rented over a period of time. And the board, Kathy, can I have? The applicant has put up for sale or lease his property to the tune of $150,000. Now, it's assumed that this is for a commercial venture that he was hoping to buy against his initial investment of approximately $52,000. The situation that is that prevails here is that he's had this for sale by himself, not through a realtor. So one was hoping to make a quick gain on it, but that's not for the moment. What we do have is two issues here, that the house could have been rented for a nominal amount, let's say roughly $750 a month. That's roughly, and it's vacant. From what I understand, construction material was put in there. You also have a two-stall facility there, like a warehouse, whatever you call it. It's my understanding, and I'd like to be corrected if I'm making a false assumption, that this facility did house, or does currently house, construction equipment and materials owned by the individual.
You're wrong. You're wrong.
Sir, and I said stand correct,
Yeah,
but...
I'm correcting you. You asked me if
Sir, I'm talking.
I'm correcting you.
You have your time to speak, please. Given that fact, even if there were not material included in the facility, you must impute, the courts have stated, you must impute a rent. Anywhere between, the probably approximate rent would be $1,000 to $1,500 a month to rent that facility. So the aggregate would come out to $18,000 for that property. But to leave it dormant, that's not for the board to say, well, you've left it dormant and you've suffered a financial hardship. That doesn't come into play. But with that said, I'd like to continue. That to the zoning board, in the case of Everhart versus Johnson, a variance was granted to the owner of a property in a residential zone to enable him to house an insurance and real estate agency. A state Supreme Court annulled the granting of the variance, which determination was affirmed by the appellate division, which found as follows: a complete lack of the requisite proof as to the first requirement. Example, that the land in question cannot yield a reasonable return if used only for a purpose allowed in that zone. And RB4 does articulate what it can be used for. The court explained its findings as follows: a mere showing of present loss is not enough. In order to establish a lack of reasonable return, the applicant must demonstrate that the return from the property would not be reasonable for each and every permitted use under the ordinance. They cite Forrest versus Evershed, 7 New York, page 256. Moreover, an applicant can sustain his burden of proving lack of reasonable return from permitted uses only by dollars and cents proof. The faxing of a delinquent tax bill does not meet the test under the appellate court rules. The dollars and cents rule was again enunciated in a Court of Appeals case, which held that a landowner who seeks a variance must demonstrate factually by dollars and cents proof and an inability to realize a reasonable return under existing permissible uses. There are several uses that are available under the present zoning in the Clinton Road area, including residential and commercial uses. An image found on Google dated August 2011 indicates that a sign was posted on the Roberts property, and a recent visit to the location shows that the sign is still there. The sign says, "For sale or lease, will build to suit." The phone number is on the sign. As it relates to Mr. Roberts' own business, Roberts Construction, it is not a realtor sign. Will build to suit indicates that Mr. Roberts is trying to sell the property as a commercial site. There are commercial uses allowed in that zone, such as retail store, restaurant, or bank, all under 2,500 square feet, a daycare center, and others. However, according to Mr. Roberts' application, he only has 12,000 square foot lot. Each of those uses requires a minimum of 15,000 square feet. The zone also allows a convenience store or automobile service station, but apparently so far Mr. Roberts has been unable to find a buyer for either of those two uses. The lot, however, does fit the requirements for a one- or two-family dwelling. Mr. Roberts' application states that he paid $52,000 for the property in the early 90s or late 80s, we're not sure as to the date. Several old-style, one-family residences on Clinton Road in close proximity to the Roberts property have sold between $45,000 to $120,000 in the last 3 or 4 years. Mr. Roberts' application states that they've been trying to sell the property for $150,000 for 2.5 years. The assessed value of the subject property is $83,900, with a full market value of $96,437. Mr. Roberts has provided no proof of current market value with his application. Based on recent home sales in that area, it is quite possible that the market value of Mr. Roberts' property as to a one- or two-family residence is less than $150,000. According to New York State zoning laws, the mere fact that the property owner may suffer a reduction in the value of property because of the zoning regulations, or the fact that another permitted use may allow the sale of the property for a better price, or permit a larger profit, does not justify the granting of a variance on the grounds of unnecessary hardship. The town's own instructions attached to the use variance application states, how can an applicant best prepare such proof for his case? By engaging a professional such as a licensed real estate broker, appraiser, not a real estate salesman, nor broker, whose sole profession is appraising. Mr. Roberts has merely provided the zoning board with a copy of his tax bills and a statement from a sales associate of Hunt Commercial Real Estate that they had difficulty selling the property. Mr. Roberts' submission lacks any dollar and cents proof and also lacks any proof of market value as determined by a licensed real estate appraiser. His application is merely based on statements that are unsupported by factual information or proof. Mr. Roberts does state in his application that the area needs to be rezoned on my side of the street. That is a separate issue remedied by a revision of the general zoning regulation, not by granting the special privilege of a use variation to a single owner. The codes officer has stated that the updated zoning and comprehensive plan will, if adopted, allow this use. However, for the moment, these regulations are merely a draft, and they may not be implemented as if they were in force. And they are still subject to a public hearing or town board approval of either the comprehensive plan or the zoning regulations. A use variance should not be permitted based on what might happen in the future. I thank the board for listening.
Thank you. Is there anybody else that has a comment on this particular application?
Sure,
Yes, sir.
I got a comment. I'm actually here in addition to my own house, but I actually I'm talking as a private citizen.
Name and address.
George Boris, 11 Tamarack.
Welcome.
Thank you. I'm actually in healthcare. I'm a general dentist for the state. I have a practice of my own, but I would love to see a vet's office down the thing. I think it would be better than the eyesore that's there. And I think in this economy, you know, to see another professional moving in only brings up the neighborhood better. We have an ice cream shop right on that side. We have other commercial things. We had a pizza place there. I don't see, I mean, I understand, I mean, I used to be in the FBI and stuff, I understand the rules and regulations, but, you know, when I hear that the potential to bring a vet's office here, we're not bringing large animals, there's no incinerator, crematory, I would be in support of it, and I live, you know, I pass that every day on the way, so just wanted to throw my 2 cents in.
Thank you for your comment. You're welcome. It is right. Yes, sir.
Yeah, Ken Kostelecki again here, 44 Clinton Road. Geez, I was here last month and I got quite an education. I'm glad I stuck around. It had to do with another issue of, well, related to the Roberts issue of his variance. And that issue was, there was a couple of gentlemen here trying to persuade the board here that their property across from Barnes & Noble, Commercial Drive, was suitable for a restaurant. He didn't say what kind of restaurant. I tried to find out. That's beside the point. However, I got quite an education that time. I burnt the midnight oil, so to speak, hit the law books, thanks to the board here. And lo and behold, I come up with this 40% thing, green issue. And the exact thing that the board was bring to the attention of these two applicants that you cannot, with 40%, well, in his case, he's got up to 12,000. There's no way that Mr. Roberts can prevail on that point alone on this green issue, and I assume that that restaurant is going to go down the tubes like you indicated the last time, if I'm correct. So I've gained quite an education here the last month and hit the books, and this 40% green thing disbars him from even thinking about that cat hospital, let alone any other kind of thing that he may want to put up. New Hartford has a very serious problem with drainage, and that would impinge upon my neighborhood too. The whole neighborhood that, I got these 45 petitions or so against that I submitted to the board last month. So I just want to rest on that. And maybe, Mr. Is your name Wyatt? Or maybe you might want to add a few more words. Did I cover it all right?
Well, let other people speak.
Let other people talk.
Thank you for your comments. Is there somebody else who would like to speak on behalf of this particular application? Yes, sir.
I'm Bill Richards. I live about a wedge away from that property down on Wynn Avenue.
Welcome.
Thank you. I can't think of a much better use for that property. I've been looking at it for 42 years, and it's pretty nasty as it is. And we're hearing that a car dealership would be okay, or a gas station. Would that be better? I don't think so. That's all.
Thank you for the comments. Is there anybody else that would like to speak on behalf of this particular application? Yes, sir. Mr. Woodland.
The concerns that I have representing that area is we've had down the road some of the traffic and the parking concerns there, so I just want the board to be aware of those concerns too.
Okay. Thank you. Is there somebody else that wants to speak on behalf of this particular application?
I just have one follow-on comment, Mr. Chairman. Board member Montrose indicated that whether or not there was action taken on removal of debris, and I happen to be in the vicinity on Sunday. There is quite a bit of debris, which appears to be a code violation, in my understanding, on that property, and I don't see how this could be used as burn material. I mean, I know what goes into the burn, but you've got this situation over here, you've got cars, you've got other wood in that area, but the most important point to focus, and this is just ancillary to the 4 points that are required to be taken under consideration by the board, but the most important one is the financial, and based on what was received by the town and this board, he does not meet on that, and as well as others, but that alone must be used as a basis for denial of the application. Thank you, and I'm done.
Thank you. Is there anyone else that wishes to speak on behalf of this particular application? Yes, sir.
I guess, if I lived in the neighborhood and somebody wanted to bring a veterinarian clinic in my neighborhood, I can't understand I'm just bewildered at all the residents that came out opposing this, and I thank you and the other gentleman that was, this is such a low impact usage. I can't think of a better use. I think the neighbors should have came out and said, yeah, it's a great idea. We're talking about possibly putting a gas station there. I don't know what the other uses were, but just a gas station alone, a repair shop, is that what they want? Do they want 25 cars sitting out there waiting to be repaired? Is there a code for how many cars you can have in your gas station parking lot that are waiting to get repaired? Is that what they want? Because if that's what they want, that's what I'll target, and that's what I'll wind up getting. Because it's really ridiculous that I'm bringing a great usage, that the gentleman that's going to run it is probably, it's not going to run crazy hours, 8 to 4, 4 to 5 days a week, cats alone, no boarding. I can't believe it.
There'll be cats sleeping overnight.
I just can't believe that there's this much opposition to it. And I bought the property almost 30 years ago for $52,000. okay? And is it worth 150? I don't know, I think it is. It's got 2 buildings on it. I put a lot of money into the buildings recently. Of course, they'll tell you about all the debris that I have sitting on the property, but they didn't tell you that I just put 10 grand into the building with siding and all new windows. The whole interior's been redone. I mean, they don't tell you this, they tell you the negatives. They don't tell you any positives, it's all negative. But if I was a neighbor and I was living across the street and somebody wanted to bring that usage to my neighborhood, I would roll out the red carpet for them. I just don't get it. I don't get it.
Appreciate the comments, Mr. Roberts. Is there anyone else that wishes to speak on behalf of this particular application? Okay, we'll close. I don't think there's nothing new on this, right, Dory? We didn't get anything additional from anybody.
No, just today.
All right. I guess, you know, we can talk about this. Comments from anybody? I understand, I guess maybe I can start off. I understand where the applicant is, and I understand, I think we all understand the criteria, the use variance. While it may be the most, it may be the best type of use for this property is to put this clinic in here. When we take it, look at the criteria, that's really what we have to be guided by. Does it meet the criteria or not? Because if it doesn't, even though we think that it may be the best use for it, we're not allowed to do it. Even as Joe mentioned at the last meeting, that this may be zoned to allow this type of business in the future. You know, I know we asked Joe, what are some of the potentials that could go in there? You're gonna find something, and I know that, you know, the residents that presented the petition, they said that we don't want this in there, but what's allowed in there could end up being something that they don't want, but they may end up getting it. But we can't be guided by that. We have to be guided by the criteria. Even, you know, so, that's what I'll say, starting us off. Does somebody want to follow up to that? Ivan?
One is, I think the petition that was turned in from the neighbors really centered on not wanting a crematorium or not wanting overnight stays. And I think the applicant last month, anyway, through my notes, was willing to do both of those along with providing the parking. But in essence to what was said last week by Karen, and Lenora started and Karen finished it, and now by Mr. Waiter tonight, I don't think we have a complete application in front of us. And in absence of the dollars and cents review that were not provided by Mr. Roberts, I think we're in a position to say either has an incomplete application, he can pull it this month to complete it, or we'd be in a position to have to deny it, without prejudice, of course. Even though I may be favored of yours personally.
I basically would share the sentiments. I think it is the best use. I think it would be a great idea. I would, last month, in trying to follow what we need to do as a board, asking for the criteria, I was hoping to see the dollars and cents exact, to show the exact loss, and I was really confident that we'd see it so that this could get passed. And then we could go and it would meet our criteria.
And you don't think we have that?
I don't think from here we don't, no.
Sorry.
No.
Okay. Brett?
My only comment is, basically, I think it's important for the people in town that are here from the town know and understand that we as a board attend several hours of training every year. And what is the use variances, what are acceptable, what are area variances, and what is acceptable. And to be reminded of those particular things from the audience is a little bit insulting to me, and I kind of resent that. When it comes, we also have here our town attorney to keep us straight, and before we vote on any application here, we review every one of those applications based on what the laws of the state of New York says. As far as this meeting, its requirements, I don't think so. Okay?
As far as the applicant, yeah, doesn't meet it.
I don't think it does at this particular point in time. I
Okay.
think it, again,
I think it could.
I think it could, but, you know, again, is it a low use impact? I definitely think so.
Sounds like, at least what I've heard from the three of you so far, maybe I'll put words in your mouth, but,
It could be
it sounds
worse.
like we're all, well, it sounds like we're all there except for the dollars and cents.
Yeah, we have to, you know, again, the burden of proof is on the applicant, and that it's not present at this particular time, I don't think.
So what do I have to be bankrupt?
It's not about you.
Oh, really? It's,
No, it's not about you.
Me?
I'm done. I'm done.
No, it's about the way.
You're gonna get what you don't want now.
And what they said, but the point is our personal feelings about it, do not factor into it. You just have to go by criteria, else we'll be overturned possibly too. I mean, it's not, we don't have an option to just say, well, we believe that it would be a great use and will impact it. It's irrelevant.
And it may be.
And it does make it difficult.
No, you know, it's.
It may be,
It may
that's
be
what
that,
makes it difficult, exactly.
it may be the best use, it may be the best use, it may be low impact, it may fit in the best.
Can I ask the applicant a question, or is this closed?
We're closed right now, let's hang for that just for a second, don't lose that thought.
Yeah, and, you know, and so that's basically, the criteria. I mean, the only thing I can say is I don't know when, as Joe told us, something in the future is coming up. I can't say when it is, but perhaps at that point it will be permitted use. Right now, it's something
And I know you've always kept us, you know,
Mhm.
cognizant of the fact that to look at the dollars and cents on a use variance.
Well, we have to.
No, I know, but
Mhm.
that's always at the top of your list.
Yeah.
Oh, you still got that thought?
Just,
We'll open it back up.
I don't know if this sounds, now, were you aware?
So you have to have a hardship to allow a good usage on the property.
For
There
us
has to be a
vote,
hardship for me.
and it has to be proved with the
Has to be
dollars.
That's okay, let's go. You guys are crazy, you really are.
Yeah. That's okay. John, where do you?
For me,
Where do you?
I don't think this is what we requested. I mean, it's a tax. It doesn't say that the property was up for sale for 6 months or 8 months or 10 months, if there was a realtor in it, or if there wasn't. I really think the camp hospital is a clinic is a great idea because it's very low impact when you can put a gas station over there and you can, there's 100 things you can put over there. And just down the road, there's talk about
You got
animal cemetery
yeah.
going in there.
Well, you
So-
got a number of commercial uses on that side of the road all the way down.
But the thing that we asked for, in my mind, is the stopper is right here.
We didn't get it.
That's, you know, otherwise, I have a real problem voting against it, to be honest with you. We got the financials.
I think it's a perfect fit for it. If you can bring back the proper documentation, I have no problem with it, considering what comes out there. That's really all I have to add.
So I guess I would say at this point, what's the, somebody do we want to look at the criteria? And, well, I guess my comment is that, do we want to make a motion on passing or denying, or do you want to give the applicant another opportunity? I guess that's or do we want to
Is he asking for another opportunity?
I don't know.
Can I say something?
Yeah.
What exactly is the financials that you want? Exactly what you
I
want?
think-
Because what I was, I'm sorry, I didn't mean to interrupt you, but what,
No, I was gonna answer
what we
what you'd like.
understood, what
He
we
he could
were,
probably answer pretty good.
we're told is
This is
your
what-
tax bill, if you have outstanding taxes, and if you tried to sell the property, showed that you tried to sell the property. That's what we were told, that's why we submitted that.
By
And if you
the
told me
original.
something different, I would have gotten that material together as well.
I think, is it listed in the,
What you really have to have, and what needed to be done, and I thought that's what we were gonna see, is for each of the permitted uses within the zone, an analysis would have had to been done, as compared to their rent, the cost to make it that way.
You want a
to see-
professional analysis, you want us to hire somebody to come out and look at the property, that's what you want.
That would
and
be
like
the
it said
best.
in the other
Yeah.
Each of the permitted uses, for example, where a convenience store is allowed, they'd look at it, they'd look at the per square foot that to construct them, because it'd have to be new construction. They would say if it could be put on, it would be built at $150 a
I know
square
all
foot,
about
you could
that,
only
yeah.
get this much rent. And then they would do an analysis for each to see if there's a profit that could be made. If it shows that there is a profit that could be made, then he would need to address that. If it shows that it's a negative return, which is possible, because the cost to construct something would be more than the rent that he can get, then it would show that he couldn't do it. And then as I think was brought up by Mr. Whiter, with the use it as a single-family house at $750 a month, that would be included in there. The value would be determined today at today's cost. He bought it, I think he said he bought it 30 years ago. So if it was worth 150, or if the neighborhood was worth 70 to 80, or whatever the price is, he would look at the value as a single-family residence or two-family as an analysis for each of the permitted zones, each of the permitted uses. Then you come back, and then it's our decision. Providing he gives us that information, it would be this board's decision, because I think this board, at least I won't speak for any of them, but for me, I think it did work. It was a fit, and we thought we'd see something, an analysis that we would be given so we could analyze it.
Well, we weren't told an analysis, it's just a hardship, so that's why, and somebody did tell us that's what we were to submit, so that's why we submitted that. Now, we'll go out and hire somebody to analyze all these different usage and put all this money
And they'll
forth
make a
to do
little-
all that, just to prove to you that this is the best use, that we tried to rent it for.
Not the best
it's
use.
not the,
Not the
see,
best
it's
use,
best
this
use, we'd
is-
probably be saying
The other
yes, it's
uses
what
are
we
not
need.
profitable.
Exactly,
Cannot
but
create a
we tried to
profit.
rent it for
Return.
years and years.
So you'd have to
and
show
it's been
us that,
empty.
not just by the sign,
So,
show,
but how would you like me to show that? That nobody's called, nobody wants to rent it? How do you want me to show you that nobody wants to rent it or buy it?
how has it
I-
been done in the past?
Well, I don't think it was.
Excuse
It's
me.
just a sign of-
Excuse me, I'm talking.
I wasn't talking to you. I was just,
You're being disruptive.
ma'am, please.
Well, anyways.
What does it say on the criteria that we're going by, that they must show not just, because it also says what we have to, it's not that what we want to do, it's what we have.
This is the short.
It even says that it's not even
Yeah.
just
What do you
unique
want?
to you.
It's right here, Lenore.
The blue thing?
Did they get a copy of that when we
No.
had, the original
I don't believe I got a copy of
application?
that.
It's right in the application.
We'll give you one. This is where it talks about it, and then elaborates on the fire.
Yeah, it's on your first application.
I have that in the office, I'll take a look at that one.
It does spell it out there.
But for the person that's not involved in real estate, it is difficult to understand. And I think for the board, we even grappled with it last week, and Karen and Lenora talked about it. But it's something that would have to be done for each of the uses. It's an extensive report. And I guess further, if you'd like, I spoke with the Department of State about this particular case to find out the rationale of why this law was put in for this very case of a lesser use on a piece of property. The board felt, and generally I think from hearing them all talk, or most of them anyway, that it was a reasonable use for the property. So we'll see what they say when they get back to us about why they put the law in the way they did to force us to have to deny. Where Mr. Roberts left, what he doesn't understand is the law is very specific. You have to deny. There is no maybe, we got a choice. If you don't provide the information, we have to deny. Now, without prejudice allows you to come back. And that's what the best we could do, unless you wanted to table it, until you provided this other information. Herb? Joe?
Difficult to have to sometimes
Is
go
that about
against
it?
what we want to do.
Right on.
because the.
Right on point,
have to
right.
follow this.
So,
Well, I guess,
Well,
if-
you can move without him here, you don't need him here.
no, I know that, but if they wanna come back,
Do you want?
we could table it. If you don't, if you wanna do it, we could make a motion without prejudice, which means you could reapply, but then you pay all your fees all over again.
No, you can table it, because we'll do the homework we have to, something's going in there, whether, you know, the neighbors probably won't like what ends up going in there, but something is going in there, because it's not gonna stay vacant.
Well, they can only do it.
We have
So let's-
from the applicant that we would like to, I know
That's-
who the applicant is, I mean, it's just, but this is just a gentleman who left.
Yeah.
Is
That's
the
my
other-
husband.
Well, you
That's your
can
husband?
move, you can move to table the application because you don't feel you have sufficient data.
Okay.
And give the applicant 60 days, 90 days to resubmit, that's all.
But
All right.
does he have to be in?
No,
No.
absolutely not.
No.
You're doing it without his consent. You're doing it on your own
Okay.
initiative.
so,
we
does
table it,
somebody,
give
does
them
somebody
like-
wanna make a motion?
I'll make a motion to table
Good, you make the
for 60 days to allow the applicant to provide the information that's required.
If they can get it sooner, can they come back to me?
Oh, yeah?
Yeah.
I think we should give them up to 90 days, just because.
It might be
Do
details.
you wanna change your
I,
motion to 90 days?
Make it 90.
Just so that, you know.
Okay.
Second.
Second by Lenore. Fred?
Aye.
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 Aye. Okay.
Motion to table carries.
Thank you, board.
Okay, thank you. Thank you so much.
It's been very educational.
Thank you.
Why is she so adamant?